Nobody where they pour milk and honey for a mouth when no go lick mouth. You understand? These judges now they come out, come support Wike when they build house for Abuja judges. Remember, say many prominent Nigerians don't criticize Wike, say the house when they built for judges for Abuja, now direct way of making the judges to compromise on any court case when concern Wike or President Tinubu for Abuja, when go make judges no go they give correct judgment for cases when they for court. Now one lawyer don't come out, come they support Wike. They come they blast Falana, they blast Deji, they blast Odin Kalu.
The judiciary cannot function, and it is not expected to function optimally in an atmosphere of distrust, political rascality, born out of partisanship and of self-interest. In a democracy such as ours, judicial independence, impartiality, and accountability constitute the engine room upon which such a judiciary is fired. Our Constitution, that is the 1999 Constitution as amended, possesses sufficient safeguards by way of constitutional provisions that guarantee the independence and impartiality of our courts. At this point in time, it is very important to draw attention to the fact that our Constitution, being a written Constitution, must be read as a whole. I humbly submit that it is not permissible to take isolated parts of the Constitution and give it a construction that suits the political idiosyncrasies of persons who apparently for personal reasons do not see any good in the judiciary or in our justice system. Since the return of the democratic system of governance in 1999, the Nigerian judiciary has been aggressively subjected to excruciating campaigns of calumny by those who consider themselves not favored by civil judgments arising from election and indeed political matters. The genesis of the situation is not far-fetched. It began when the judiciary, epitomized by the Supreme Court of Nigeria, began to move away from their decisions of non-interference in political matters, especially matters arising from or relating to the internal running of political party. This position was settled by the Supreme Court decisions in the celebrated cases of Onoha against Okafor and Daudu against Turaki, where the Supreme Court took the view that political parties are supreme over their internal affairs and that they exercise sovereignty over matters concerning issues of sponsorship or of candidates and the domestic running of the affairs of their political parties. In other words, that the internal affairs of political parties should not be a matter of interference by the law courts. These decisions, that is, Onoha and Turaki, heralded a period of judicial self-restraint, whereby despite the bombardment by politicians on the courts, or to change their court's position to one of interference in political party internal affairs, the judiciary refused to budge until the politicians themselves, through one of their main organs, which is the second arm of government, the legislature, introduced the provisions of Section 34, subsection 2, Section 87, subsection 9, to the 2007 and 2010 electoral acts into our electoral jurisprudence. These provisions led to a radical departure by the courts from the position of restraint, which was epitomized by the judgments, the later judgments of the Supreme Court in Uku against Ararume and Amechi against INEC and others. From that point, the floodgates were opened, and it became an open sesame for politicians to approach the courts on the cover of statutory license as provided by the Electoral Act of 2010 and 2022, juxtaposed with the overarching influence of the provisions of Section 285 of the 1999 Constitution as amended. All I've said is that these provisions moved the courts from the position of non-interference in party matters, and there is now statutory liberty and license for courts now to be bogged down with cases of who is the correct party chairman, when should party pyramids be held. So we have moved from that position of judicial restraint to the position of, or I will explain the consequence of this as we go. Please bear with me. I do not intend to elaborate on the effect of these decisions of the court and provisions of the law, as that is not the objective here. The purpose of referring to them is to draw attention to the fact that it is this opening of the floodgates in approaching the courts by politicians in respect of the internal affairs of their political parties that has inundated the Supreme Court, the Court of Appeal, and all other courts with an avalanche of criticism of absence of judicial independence and other wild and malicious allegations of judicial inducement and interference over what clearly arose or emanated from historically and constitutionally justified day-to-day acts of government. In the past few months, a cross-section of the legal intelligentsia have labeled the executive actions like the purchase of vehicles and other hardware, the construction of official residential quarters for judges, the renovation of courts, and the construction of new courtrooms by the executive arm of government, states and federal, as amounting to inducements and the purchase of justice from the courts. From all available empirical evidence, the foregoing allegations are untrue, malicious, and only designed to portray the judiciary in very bad light. Even though the Honorable Minister of the FCT, through his special assistant, one Larry Olayinka, have denied that there is anything untoward, illegal, unlawful, unethical, or unconstitutional in the building of judicial quarters by the executive arm of government. The same intelligentsia is adamant in their position that such a measure is illegal and unethical because it amounts to a breach of the rules of the separation of powers. To debunk this postulation, it is necessary to give a brief description of my understanding of the doctrine of separation of powers. Chairman, please bear with me. It is a basic principle of constitutional law that defines the functions and responsibilities of the three branches of government: the legislature, the executive, and the judiciary. The framework, or this framework, is designed to prevent the concentration of power in any single entity, thereby safeguarding individual liberties and promoting a system of checks and balances. This concept can be traced back to the ancient political theories, but was most notably articulated by the French philosopher Montesquieu in his seminal work, The Spirit of the Laws, circa 1748. Montesquieu argued that liberty could only be preserved when the legislative or the legislature, executive, and judicial powers were held by separate entities. He posited that if these powers were concentrated in one body or individual, it will lead to tyranny and oppression. The idea was influenced in earlier thinking by earlier thinkers such as John Locke, who emphasized the importance of a divided government to prevent abuse of power. The question to ask is, if there exists in this world a democratic system in which there is a watertight or ironclad compartment as to how the three arms of government operate. In other words, do the functions of these three branches of government overlap? About 48 to 50 years ago, I was a student of constitutional law at ABU Zaria, and our dean, Professor Manan, taught us these elementary principles. And gladly, we did it, comparative constitutional law, with my senior, but he came to read masters, and we did masters, comparative constitutional law, and these same principles were held. The Honorable Justice can bear me witness. And it is settled in law, as I shall demonstrate, albeit briefly hereunder, that no democratic system has a strict application of separation of powers because governmental powers and responsibilities are too complicated and interrelated to be so compartmentalized. As a starting point, it is necessary to highlight the provisions of Section 4, 5, and 6 of the 1999 Constitution, and that set out that the provisions of Section 4, 5, and 6 of the Constitution set out the broad powers of the executive, legislative, and judicial arms of government. For instance, to enhance its representational status, the Constitution further below bestows limited executive, financial, quasi-judicial powers on the National Assembly. There have been frequent conflicts between the executive and the legislative branches over budget allocations and implementation. As recently as late 2023, there was significant controversy over the National Assembly's modification to the 2024 budget proposed by President Tinubu's administration. The legislature had increased the budget originally sent by the executive with over 1.2 trillion naira, raising concerns about fiscal discipline, breaches of the rules of separation of powers, and balance of power in budgetary matters. In the United States, government shutdowns have occurred when the executive and legislative branches failed to agree on budget appropriations. You remember the 35-day shutdown in 2018 to 2019, the longest in US history, resulting from disagreements between President Trump and Congress over border wall funding, illustrating how budget conflicts can paralyze government operation. Under Section 88 of the Constitution, the National Assembly is vested with powers to conduct investigations into any of the matters on the exclusive and concurrent list of the Constitution, and the conduct of affairs of any person, authority, ministry, or government department charged or intended to be charged with the duty or responsibility for executing or administering laws enacted by the National Assembly and disbursing or administering monies appropriated by the National Assembly. I'm sure, Mr. Chairman, you have attended oversight committee sessions in the National Assembly. And why I've mentioned it is that these are clearly activities of the executive, the departments of the executive can supervise themselves on. But the Constitution allows the overlap of powers by the legislature to look at what executive agencies of the executive arm of government are doing. So that if there was strict separation of powers, there would not be oversight sessions in the National Assembly. However, the powers so conferred on the National Assembly are exercisable only for enabling it, as it is said, to make laws with respect to matters within its legislative competence and correct any defects in existing laws, expose corruption, inefficiency, or waste in the execution or administration of laws within its legislative competence and in the administration of funds appropriated by it. Thus, in the normal democratic system of government, It is not unusual to see the executive exercise legislative powers by the making of executive orders. They also exercise judicial powers by making subsidiary legislations to authorize its agencies to impose fines on transgressors of the law. See, for example, the powers of the Consumer Protection Council, the Nigerian Communication Commission, and many other federal agencies that have the powers to impose fines on persons that have business to do with them without such agencies being accused of exercising unlawfully or unconstitutionally judicial powers. Also, as stated above, it is not unusual to find the legislature authorized by the Constitution to exercise judicial powers in the course of its oversight functions, either by committing members of the public for contempt of the legislature or sitting and conducting hearings, inviting witnesses to testify before it. I see it as if it is a court of law. The judiciary, on the other hand, also exercises executive and at times legislative functions. Judges propound and make laws within the body of their judgments. I see the local government autonomy keys as a lawmaking jurisdiction of the Supreme Court. They award contracts within their domestic responsibilities. Many other numerous examples abound. One other vital matter to note in the matter of the construction of houses for judges within the FCT is that it is not a personal bonanza of the minister of the FCT, but an appropriated project in the budget, which received the assent of the President of the Federal Republic of Nigeria. Consequently, the way and manner the said critics have been going about it as if the minister of the FCT is constructing the buildings out of his own personal purse and doling out largesse, and in his individual capacity is unfortunate. Once this distinction is recognized, it becomes clear that the hallowed office of the judge cannot be corrupted by merely giving to them their entitlement or any accoutrement due to their office. In other words, that because you give the courts, the judiciary, what is their right under the law, does not mean that you are corrupting the courts. It will be too far-fetched to say that. Historically, providing accommodation for judges and or judicial officers dates back from colonial times. We are privy to the knowledge, and our official records and documentation bear us out that judges have been provided housing by the executive arm of government since colonial times in government reservation areas of virtually all urban cities in Nigeria. I know where the judges' quarters are in Zaria, Kanu, Ikoyi. Judges have always been provided accommodation, so it wasn't a new thing. This practice was stopped around 2007 when it became government policy to monetize housing and other perquisites of office under the guise that government will be saving more money when it pays rent for housing and buys vehicles for its staff across the three arms of government. The judiciary was the first to back out of this arrangement. I was in the NJC then, because it discovered that the withdrawal of accommodation from judges, especially newly appointed judges, exposed them to danger of having to rent accommodation in anyhow areas of the town, which exposed them and their families to great danger. Imagine a judge who should be staying in Maitama because of the hallowed nature of his office, now goes to Uchibe now, or one of these suburbs, because he finds it cheaper there. And one day he comes across somebody who was tried for one violent offense or the other. That one brings his gang to sort of deal with him. Would we say we have saved money? by not giving him accommodation where he should be, instead of paying him off and say he should go and take accommodation anyway. Thus, now that this service is being reinstated by the executive, which is the appropriate agency to carry out such works, some people are losing sight of the big picture and have reduced the matter to one of party politics without considering the overall benefit of the provision of housing by the executive to the safety, independence, and impartiality of the judges in question. Finally, on this point, it ought to be noted that the three arms of government work in tandem and in a coordinated manner. They do not work at cross purposes. Thus, the Constitution expressly vests the function of submitting budgets, executing laws, planning for both the legislature and judiciary on the executive arm of government. Moreover, judges are sworn on the holy books, the Bible and the Quran, to dispense justice without fear or favor, or ill will or malice to anyone. One will be thinking very low of our judicial officers if it is thought that their judicial oaths do not count for anything. I have previously extensively dwelt on this aspect of the opening remarks. these opening remarks for the simple reason that quite a number of people, mostly politicians and their friends and advisors, have lost sight of the fact that the judiciary does not exist solely or exclusively for the resolution of electoral or political disputes between politicians inter se. Judicial officers or the judiciary resolve other disputes, and these disputes may be commercial in nature, criminal in form and substance. They adjudicate on and resolve disputes of personal status in the form of chieftaincy disputes, family, contractual tortures, and even constitutional disputes. Thus, political cases are just a microcosm of the variety of cases that the judiciary adjudicates upon. Consequently, if the political class is allowed to destroy the image of the judiciary willy-nilly, then it is the society that will suffer massively for it, and at the end of the day, it might be impossible to return to the status quo. The criminal justice system earnestly needs the judiciary in order to sustain the equilibrium between the society and persons who are prone to disrupt the peace, order, and sanity of the same society. We should not sacrifice the stability of the society, which is hinged on the ability of the judiciary to perform its functions without intimidation, fear, or bullying, on the political altar of very angry politicians and their advisors when they lose cases.
Now remember I said Falana, Deji, and some other prominent lawyers for the country don't berate Wike when they just tell Wike, say Wike don't get any right to build houses for Abuja judges. But now this lawyer, they come out, they support Wike when they build houses for Abuja judges, say that the right thing to do, say they don't get any right to stop Wike from building houses for the judges. Remember I say Wike don't argue, say that the responsibility of government to take care of the judiciary despite the presence of separation of power. We can say separation of power not mean saying they don't go take care of judiciary. Recently, because of criticism, we can distance itself from the project. When they talk in President Tinubu, now give an order to build houses for Abuja judges after the criticism done too much.